Okay, we'll go ahead and get started, and Mr. Maggio can join us. At this time, I'd like to call the meeting to order. Today is Thursday, September 9th, 2021, and this is the meeting of the Rent Stabilization Commission for the City of West Hollywood. Commissioner Montemayor, welcome back. I believe you were missing last time. Would you like to do the Pledge of Allegiance for us, please?
Yes, one second, sorry.
That's all right.
I have my dog, just 1 second.
Patriotic dog.
Can you hear me?
Yes.
Okay. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Perfect. Thank you very much. Mr. Secretary, may we have a roll call for tonight, please?
Commissioner Ayers?
Here.
Commissioner Kirby's?
Here.
Commissioner Maggio has not joined us yet. Commissioner Montemayor?
Here with my dog, Preston.
Commissioner Thompson?
Here.
Vice Chair Copeland?
Here.
Chair Marks?
Here. Thank you very much. We have a quorum. Has everyone had a chance to review the agenda for tonight, September 9th? I see a lot of heads saying yes. Do we have a motion?
I move that we, I'll second.
All right, looks like we have a motion and a second. May we have a roll call, please?
Commissioner Ayers?
Yes.
Commissioner Kirby's?
Aye.
Commissioner Montemayor?
Aye.
Commissioner Thompson?
Aye.
Vice Chair Copeland?
Aye.
Chair Marks?
Aye. The motion passes. Thank you very much. All right. We have the approval of the minutes next from August 26, 2021. Has everybody been able to review those? Yes. Any changes? Seeing none, do we have a motion?
I move that we approve the minutes of August 26, 2021.
Perfect.
Second.
All right. We have a motion and a second. Mr. Secretary, can we have a roll call on that, please?
Commissioner Ayers?
Yes.
Commissioner Kirby's?
Aye.
Commissioner Montemayor?
I'll abstain as I was absent.
Commissioner Thompson?
Aye.
Vice Chair Copeland?
Aye.
Chair Marks?
Aye. The motion passes. Thank you for the roll call. Do we have any public speakers?
Not at this time.
Okay, great. Moving right along to the manager's report, Mr. Holland.
Good evening, Chair, Vice Chair, Commissioners. Jonathan Hollow, Rent Stabilization and Housing Manager. As you can see on the look ahead, tonight we've got an appeal and also a resolution related to last meeting's appeal. On the 23rd, there is going to be one change. We're only going to, the commission will only be hearing D4581 and the other three that are on the calendar we push back, but everything will be heard before the end of October, when there'll be a little break. As I mentioned at the last meeting, all the commission meetings fall on holidays in November, so there'll be a little break, which will give staff time to fill up this calendar, which I assure you we will. I also anticipate that the regulation amendment to the security deposit formula that the commission approved at its last meeting will be going to council at council's next meeting, which is September 20th. So look for that. Another reminder to tenants or landlords of tenants who are in arrears due to COVID-19 to visit housingiskey.com. If you're not sure about whether you qualify for the reimbursement of rent for the period of the local emergency or the COVID emergency, we encourage you to visit and apply anyway. Again, that's housingiskey.com. And if you have any questions about that, feel free to reach out to rsh@weho.org or to call the number that's on the website. That's all I have. Is there any questions?
Seeing none, Mr. Holland, thank you very much. All right, moving on to commissioner comments. Anyone have any comments for us tonight? I see a silent group of commissioners here. All right, maybe some towards the end. We'll move on now to the appeal. Do we have both of the parties here, Mr. Secretary?
We do. I'll admit them now.
Wonderful, thank you. And for the record, this is D-4582. All right, it looks like we have both parties here. Tenant party is Mr. Loftus. All right, and then the property owner, property manager is Emmett Ox Investments, representative here. That's Mr. Filipko.
Yeah, that's right. We're
Okay,
here for Emmett Oaks.
wonderful, no problem. All right, I'll explain how this is going to work. Following the explanation, our staff counsel will give us a summary, and then we will go into the presentations by both sides. We're going to hear first a staff report from our legal counsel, and then the appellant, which is the party who filed the appeal, which is the property owner management company, will speak first. You'll have a total of 5 minutes to speak. You may split that time however you wish. A minute to start, 4 minutes for rebuttal. You tell us. And then the respondent, tenant Mr. Loftus, you will speak second. You will have 5 minutes total without a rebuttal to speak. So it will be an opening by Mr. Filipko, followed by 5 minutes from Mr. Loftus or his representative, and then the rebuttal with the remaining time by Mr. Filipko. Everyone understand?
Yes.
Wonderful. So when it is your time to speak, Mr. Filipko, you are first. You're going to state your name, your city of residence, and then you will tell us how you want to start your time, and then you'll proceed with your comments. And what I'm going to say here, I'll repeat in a moment, but please keep on topic. Only things that were presented during the hearing or evidence that the hearing examiner looked at can be discussed now. Nothing new can be brought in for us to consider. And as always, both sides please be respectful. So I'll have you mute. We will have our legal counsel give a summary, and then we'll be back to you, Mr. Filipko. All right, ready for the summary.
All right, good evening, Chair, Vice Chair, Commissioners. John Adalizio, I'm the legal counsel to the Rent Stabilization Commission for the city. This appeal was filed by the landlord, Emmett Oaks Investment, in response to a hearing examiner's decision determining the maximum allowable rent, which I'm just going to call the MAR. The tenant, Kevin Loftus, resides at 8221 the Longpre Avenue, Unit 12. He began his tenancy in 1975. In 1979, he became the resident manager, and as part of his employment agreement, he did not pay rent. The employment agreement, however, valued the rent at the time at $275. The landlord purchased the property in 2013. In November 2020, tenant was relieved of his duties as the resident manager. And after his termination, the tenant and the landlord have battled over the unit's MAR. And so as a result, tenant filed an application seeking a MAR determination. Landlord challenges that tenant was a tenant prior to his employment and alleges his tenancy and employment began contemporaneously. Landlord claims that once they terminated tenant's position as a resident manager, they were then permitted to set a new rent amount. Landlord seeks to obtain something equivalent to like a market rate. And according to the record, they're seeking to set a rate at $1,100. And tenant has refused to accept any offered rent increase. The hearing was held, and the hearing examiner found that tenant's tenancy predated his employment as a resident manager. And the hearing examiner determined that the unit's MAR is $371.37. The landlord's appeal claims that the decision is not reasonably supported by the findings made or the evidence in the record. Specifically, landlord is challenging that tenant was not a tenant prior to his employment as a resident manager. Landlord claims that tenant moved into the unit contemporaneously with his employment as a resident manager. However, in the appeal, landlord does readily admit that there is no proof supporting the allegations, and they simply challenge the evidence that was presented by the tenant at the hearing. Staff has reviewed the appeal record and recommends affirming in part, modifying in part, and reversing in part the decision. Staff believes that there is substantial evidence supporting the hearing examiner's decision that the tenant's tenancy predated his employment and that the base rent is $275. That is based upon the rental value established in that employment agreement. However, staff believe that the hearing examiner erred in his interpretation of the RSO regarding what is referred to as banked amounts, and therefore his final calculation of the MAR is not supported by substantial evidence. And on that basis, we recommend reversing and modifying the decision. Staff believes that this bank amount section is not applicable to tenant's MAR calculation, and that the landlord is entitled to all lawful annual general adjustments up to the date of the tenant's termination as a resident manager. So therefore, staff believes that the MAR of the unit is $576.36. Therefore, based upon the above, staff recommends adopting resolution RSC 21-599. You as the commission have the power to affirm, reverse, modify, or remand the appeal decision of the hearing examiner. The commission reviews the hearing examiner's decision under the substantial evidence standard, which requires the commission to make sure there is substantial evidence that reasonably supports the hearing examiner's decision, is credible and of solid value. If that evidence is found, then decision must be upheld, even if there is also evidence that could support a different outcome. The commission does not substitute its judgment for that of the hearing examiner or reweigh the evidence. As it relates to questions of law, the commission applies an independent or de novo standard of review to the hearing examiner's conclusions of law. Thank you.
Thank you. Commissioners, questions? I know this is not a topic we talk to as often, so any questions? Yes, Commissioner Kerpes.
Yeah, I just want to better understand the argument about the difference in the rents or the difference in the calculations. So can you kind of walk us through that? Why?
Sure.
First of all, I didn't quite understand why the code has a very specific window. Do you know why like it cuts it off at 1996? Do you know?
My understanding is that that's when Costa-Hawkins came into effect, which created a vacancy decontrol. And so this was in an effort to not violate Costa-Hawkins.
And then is it your argument that after 1996, we just assume the rest treated it as anything else? Or I guess maybe could you just walk through how you came to your calculation?
Sure. So give me 1 second. Okay. So for this case, the commission has to determine whether or not the MAR was correctly determined. And so in order to determine the MAR, we have to establish what the base rent is, because the MAR is the base rent plus any permissible adjustments to that base rent. And so we have to look to the municipal code as to what would be the base rent in the tenant's situation. And here it's unique in that we have a situation where we have a resident manager and the termination of the resident manager's services. And so under the RSO, there's two scenarios that govern a resident manager's determination of base rent. And if you guys would like the cite to the specific section, we're looking at 17.08.010. And we'll be specifically looking at subsection G. And so there's two scenarios under this section. So under subsection F, that governs where a resident manager comes into a unit through his or her employment. So they become a tenant at the same time as becoming a resident manager. We don't have to worry about that, at least with staff's opinion, we don't, because the evidence in the record supports the hearing examiner's determination that the tenant had a tenancy prior to his employment. So in that scenario, we have to look at subsection G. And subsection G, I'll summarize it because it's included in the staff report. But essentially what it says is that in a situation where a tenancy predates the employment, after the termination of that employment, the base rent is, let me grab the language. The base rent shall be the same as the base rent charged for a unit in the building with the same number of bedrooms adjusted by the annual adjustments permitted under that title. So in this situation, I believe the tenant is in a studio. I think the hearing examiner's decision said that there were, I think, 4 or maybe 3 other studios within the unit, or sorry, within the building. So just looking at this first section, after the termination of the resident manager, the base rent would be the same as the base rent charged for, let's say there was only 1 other studio, for whatever that studio is being charged.
Sorry to interrupt you, but we know that that's not the formula we're going to use for this situation. So just
Sure.
to kind of speed things up, unless other people have other questions, that's not really my question. My question is more a little bit later on, unless everyone else does need the background. I appreciate the background. I'm just trying to get to how we calculate from when we have the second part of that. We have the base, but how are we, the difference in the calculations is what I'm curious about.
Oh, I apologize. I'm
No,
sorry.
that's right.
I didn't mean to bore everyone then. I'm sorry. I misunderstood what you were saying. Okay, so the difference in the calculation comes from this this banked amount. And so this banked amount section essentially allows a landlord to increase rents, adjustments that they properly noticed, but didn't ultimately impose onto a tenancy. And it's for this limited window of September 1st, 1985 to August 31st, 1996. And essentially, the code says that this amount is still available to the landlord to ultimately demand and collect upon a tenant. So staff's opinion is that this section does not apply to the current situation. And so this is where the difference in the calculation is going to come in, because the hearing examiner used this section and said, okay, I can stop at 1996. But staff opinion that because this section does not apply, when you look at the language of base rent for our scenario, which is subsection G, it authorizes the landlord to impose all AGAs up until the date of the termination of the resident manager. So the difference in calculation is going to be, whereas the hearing examiner stopped at 1996, it's staff opinion that you should go until 2019.
19. And why 19 versus the, I believe it's 2000. When did he end his employment? 2000.
The employment ended according to a separation agreement in November of 2020. But it's my understanding that there's been a rent freeze in effect for 2020, 2021.
Okay, so you're only calculating from the time until the departure or his end of employment then.
Correct.
I got the dates mixed up, I guess. Okay. Thank you.
Again, sorry for the snore fest at the beginning.
No, I'm sure everyone else benefited from it because it's a lengthy record. Commissioner Topshin, question.
Yes, thank you, Chair. Mr. Natalizio, well, thank you for the clarification on the banked amount, but if it's not in this case, in this particular scenario, can you give a hypothetical scenario when the banked amount would have been relevant in the calculations if something comes up?
I mean,
So just to have a kind of a better understanding, or a kind of a why was not applied, why it is not suggested to apply to this particular case facts versus what would have been different in this case or in a similar situation, but the banked amount would have been applicable.
sure. I guess it's hard to give a hypothetical because I don't want to say in a certain situation, this banked amount will happen, and then it comes before the commission.
Or what should have been
recommendation is
different?
not. But
Right.
I think
Let me rephrase it. What should have been different fact pattern here in this case for the examiner to safely apply the banked amount?
so. I think the best way to describe this is that the issue is the fact that it's involving a resident manager who was previously a tenant, and because of that, this banked amount is just not applying to that scenario, because in that scenario, a resident manager typically, and at least in this situation, is not paying rent and instead is using their services in lieu of rent. And so you can't have a banked amount in which there isn't rent. And so perhaps, I won't say definitively, but to perhaps in a scenario where the tenant wasn't a resident manager and was just a tenant, and for some reason the landlord didn't impose lawfully noticed AGAs between 85 and 96, this would then come into play. But because the resident manager aspect of it, it's staff's understanding of the RSO that's what takes it out of this banked amount.
Okay, thank you.
Yes, sorry, commissioners, other questions? Don't see any. Okay, perfect. Thank you for that summary. We will move on to presentations by the parties. All right, like I said, the appellant will speak first, Mr. Filipko, and you can unmute and let us know how many minutes you would like to split your time.
Got it. Yeah, can I do 3 minutes to start and then 2 minutes to rebuttal?
Yes, absolutely. All right, perfect. So we'll do 3 minutes and 2 minutes with the remainder 5 minutes in the middle going to the tenant. Like I said, right when we start, you're going to state your name, your city of residence, and then you'll have 3 minutes to speak, and then you can proceed with your comments. So you may.
Got it. Is that my city of residence or where the building is in WeHo?
Yours.
Okay.
Yes, just for the record of who you are and where you come from. So you may go ahead.
Got it. I'm Jonathan Filipko, the landlord. My city of residence is Los Angeles, and I guess I'll just jump into it. So yeah, as John said, it was all pretty clear. We filed the appeal because we don't feel like there was substantial evidence for the claim that Kevin Loftus, the resident manager, was a tenant before he was the on-site manager. And the reason we felt like that and we filed the appeal is because the only real account of, or evidence, I guess, of him being a tenant first is during the hearing. It's kind of what he stated verbally. He said just verbally kind of that he was a tenant first, and there was a property manager before him. And so I read the hearing decision, and it stated as truth or as fact that he was in fact a tenant first and then the RM. But the only evidence that we have on record we have a couple of things, but the only evidence we have for that is an estoppel that was filled out and signed by Kevin. And on the estoppel, it says that he began his tenancy on April 1st, 1975. And on that same estoppel that he filled out, it says that he gets free rent for building management. So the only evidence that we have states that he's admitting or basically saying that he is, in 1975, when he started, he was getting this free rent for being the resident manager. So that's kind of what I was going off of. Once we let him go, I let Kevin know, because he said, you know what, we got to figure out the MAR. I talked to my bosses and I said, hey, you just need to send us, you know, a lease or what have you, something that shows you were a tenant first, and we'll do what we have to do. And he didn't find it. He was looking for it. He never sent it to us. So we don't have anything. I'm not saying he's lying. I'm just saying all that we have in evidence is the estoppel that says he started in 1975 getting free rent for being the building manager. And then he filled that out himself. The other evidence was the check that he had for $100. And that could, you know, that could be the rent check for him, a reduced rent for being the resident manager. And then we have a employment contract with him dated later with that company. So that's pretty much it. I didn't understand. Okay, that's pretty much it then.
Okay, perfect. Thank you for that. You can go on mute and then we'll come back for your rebuttal of 2 minutes.
Yeah.
All right, is the tenant present and ready to proceed? You can unmute yourself.
Yes, thank you.
Okay, perfect. All right, like I said, you're gonna have 5 uninterrupted minutes. This is your only time to speak. Please state your name, your city of residence, and please stay on topic and no new evidence, please. You may go ahead.
Okay, my name is Jeffrey Curtin Hughes. I live in West Hollywood on DeLong Prairie Avenue.
Okay, and are you a representative of the tenant?
I'm representing Mr. Loftus.
Okay, he's there present with you?
He's right here.
Okay, we just want to make sure. All right, you may go ahead.
Okay, Mr. Filipko really is beating a dead horse because we presented a rent check, we presented an employment agreement. They refuse to accept valid documentation, though they won't provide anything to challenge it. We've gone through several different things with them, and we agree with the staff's statement about tenancy being established. We do have some questions about the base rent, but they've gone over them, and it's something that I'm sure is a detail. We really do feel that we've gone and established our case, that really there isn't any point in this, and that the staff has pretty much gone through and correctly pretty much sliced through it. Kevin's been a tenant for 40 years. He has been a resident manager since '79. There's no reason for us to go through this. The documentation is very, very clear. There has been issues of harassment and stuff, but I really feel that Emmett Ox has ignored the law, the MAR law, refused to accept valid documentation. They're really acting in bad faith. We have no problem with staff recommendation that rent increases up to 2019. That's completely fair. The only question we have is about the base rent, because it's my understanding that a bankable amount would not be the 275, it would be the 135 from the rent check.
All right, anything further?
No, that's it.
Okay, wonderful. Thank you very much. You can mute yourself and we'll go back to Mr. Filipko. You have 2 minutes for your rebuttal and you may go ahead.
Got it. I mean, I agree with Jeffrey that the documents that we have are enough. They speak for themselves. And the document says, and it's written, filled out by Kevin, stating that in 1975, he began living there as a building manager with the free rent. So I don't dispute that. There's no document that we can produce that shows that he's, not a tenant, but just, it doesn't make sense. I mean, we just need to see the document of him having a lease beforehand. But anyway, I agree because we have the documents. They kind of speak for themselves. They state, filled out by him, that he was a tenant, or that he was hired on with free rent in 1975, which is when the check is from. For the banked amount, I think that just, it seems like that's meant for tenants. We wouldn't really increase a resident, nobody would really increase a resident manager's rent. So there's no reason to like put them on notice. So it makes sense. It would make sense to calculate all the years and not just stop at that year, in my opinion, because yeah, I mean, you don't give those to resident managers.
Great. Anything further?
No, I mean, that's it. We did try to negotiate with Kevin, to come up with a fair amount that he would pay.
Sure.
And we didn't he didn't want to talk about it, so we didn't get anywhere. We're still open to it. I don't want to make Kevin leave where he's lived for 40 years. It just doesn't make sense to, treat him that he was a tenant first when the documents show that he was brought on as a manager.
Your time.
All right.
Okay.
Thank you. Do any of my commissioners have questions for either party? Yes, we'll start with Commissioner Kirby. And then Commissioner Topshian will be next.
Yes, Mr. Flipko, I have one question for you. You just stated that the estoppel, I think it was the estoppel certificate that you mentioned. The document states that he entered as a resident manager and paid $0. Can you tell me where, either on that document or if I'm mistaken on the document, where you're referring to, where he states that?
Yeah, well, it says in the comments, I'm not looking at it, but it says free rent for building manager.
Where it says, is this first of all, is this the tenant estoppel certificate? Is this what we're talking about? Okay.
Yeah, exactly.
You're talking about question number, lease terms, B, date of lease 4/175, name of the current tenant, and then where it says current monthly base rent, none. Is that where you're referring to it as?
I was referring to the sentence that he wrote that says, free rent for building management.
In response to, is that, okay, tenant has not been given any rent, free rent, partial rent, rebates, or rent abatements, or rent concessions of any kind except as follows, and he wrote free rent for building management. That's what you're referring to?
Yeah, exactly.
Okay.
Yeah.
Thank you.
For my fellow commissioners, that is page 34.
I'm scrolling down to it now. Sorry.
That's all right. We'll go back to that if you have anything to add, Commissioner Topshian, or Commissioner Kirby. Did that answer your question? Yeah. Okay. Great.
Yes.
Commissioner Topshian.
Yeah, thank you, Chair. I had exact same question, but you answered. The other part is the question that I had. It's just for clarification purposes. When did the tenant start paying $100, and why $100? How did you, why did you decide that he has to pay $100? I'm just curious.
So yeah, when we brought him on, oops, sorry, where's the Zoom meeting go? This was before I worked here, but we come up with a deal for resident managers. We have them all pay a certain amount for rent, and then we pay them a salary, usually like minimum wage, 40 hours a month. So depending on how big the building is. We say, all right, you're going to pay $100 or you pay $500. They still pay rent to us monthly, and then we pay them a salary on top of that. So that was the deal they came up for Kevin, which is a pretty good one because he was doing a lot of the landscaping and stuff. So yeah, when we bought the building, that was the deal that my company offered him. Yeah, that's pretty much it.
Okay. And at the time when you requested to pay $100, were you aware about the estoppel that said no, zero rent? Did you know about the rent, how much the rent was paid at the time, at the beginning of his tenancy?
We had him fill out the estoppel, so that was what he was basically telling us
At the time, okay.
Yeah, so he's just verifying, hey, this is what I was paying. Yeah.
Another thing is more of like a comment is, yeah, we understand that you're challenging, but you don't have any documents in contrary to demonstrate or to corroborate your position in this matter. So that's why the examiner obviously received these two documents, which is the canceled check from October 1975 and the estoppel. Obviously, these are considered to be the best evidence submitted to the examiner in absence of any concrete documentary evidence. That the examiner had no choice but to obviously give a value to these documents. Although you made a good point also in regards to the estoppel, but we're going to discuss about it among the commissioners. But thank you, sir.
Yeah, we submitted the estoppel on our end for evidence because I'm not sure there's no document I can think of that states, that I don't know what that would be. So we submitted the estoppel, but yeah, I don't know what document there would be to be like, oh no, he wasn't a tenant. It's just I guess the lack of documentation.
Mr. Flipko, sorry to interrupt. Mr.
Yes,
Thompson,
sir.
did that answer your question?
Yeah, the owner answered.
Okay.
Thank you. Thank you, sir. Thank you, Mr.
Thank you. Any other commissioner questions? No. Okay, great. Mr. Flipko, you can go back on to mute. Commissioners' deliberations. Who would like to begin? Don't all speak at once. All right, Commissioner Ayers.
Yeah, oh goodness. I am satisfied with the evidence presented by the tenant that supports the hearing examiner's decision that the tenant initiated his tenancy before beginning as a resident manager. I know that, what he produced was a copy of checks. As a renter in West Hollywood and as someone who knows a lot of renters in West Hollywood, I know that it's quite common practice for there not to be a lease and for there to be scant evidence. But I feel that the tenant has made an effort to produce what was available to support, basically support his contention that he moved in as a tenant. There was somebody else who was resident manager at that time. And when that person, I guess, passed away, he assumed that position. So, we will never have all the documentation we'd like. Sometimes it just doesn't exist, but the way I see it, it makes sense what the evidence that the tenant produced supports what he's telling us.
All right, thank you. Who else would like deliberations next? Commissioner Topchian?
Yes, thank you, Chair. Well, first of all, let me, I agree in part and I disagree in part regarding the documentation submitted. So obviously, I'm not going to I'm not gonna go into the discussion whether this cancel check is authentic or not. So obviously that's not our, our area of expertise, and we shouldn't even discuss that. So there is no doubt in my mind, this is a check, a legit check. But that estoppel bothers me because I don't know why something like that would have been stated in the estoppel that says free rent for building management, and there is no rent paid, and the date of the lease is April 1st, 1977. So that inconsistency is kind of raising questions. So if I am the tenant and I'm signing an estoppel, I would definitely be careful, especially if I'm a resident manager. I know these documents can be very important later on. Then I would probably question why the estoppel says 1977 and not 1975. Those are the questions that I have that bother me. And the line E, when it says current monthly rent, base rent is none. Okay, I may say that the tenant at the time didn't pay rent with 0, or he said none. But the start date for the lease, that's an inconsistency. So, and there another the other estoppel was submitted. Is this estoppel that's submitted by the landlord, the one that says 75? And again, I'm not an expert, but that 5 looks like it's been altered to me if I'm looking at the document. So I have those questions. Another thing is, in my opinion, if the tenancy is questioned by the landlord, shouldn't the tenant produce, let's say, utility bills, or contact the utility company and say, okay, let me at least try to get the Edison or a gas company or wherever I paid the utilities from 1975 to get something to place me in that apartment, or DMV records, the car registration, or any type of records with, whether a utility company or any government agency that would, corroborate that the tenant's assertion. So those are the questions. Although we can say this one cancel check may establish, and that's what the examiner is using. So what was presented to the examiner used, and I cannot just say the examiner erred unless I have a document that would contradict the findings of the examiner. So I guess if I was the examiner, I would just maybe ask a little bit more questions or request more documents. So that's one of my concerns, and I want to hear from my fellow commissioners what the commissions would think about it. Regarding the calculations, the legal counsel explained that, and I had those I needed a clarification on the bank amounts, although I still, not fully convinced, but the council clearly stated when and why this bank amount should not apply. So, and I'm not going to challenge it. I may not like it, but there's nothing I can do about it, because that's what the intent of the RSO, or that's what the law says, unless the commissioners will convince me otherwise about the bank amounts. So, then that leaves me with the question whether I'm going to support the proposed resolution. Well, I definitely think that this case should go back. So now whether whether just for the determination of the MAR, or maybe for the clarification on the also the predate tenancy. I don't know. I want to hear from other commissioners, but I definitely am going to support the kind of a position on returning the case back to the examiner. Thank you.
Great, thank you. Commissioner Kirby.
I have a couple questions. If I can ask Commissioner Topchin, I'm confused about some of the comments you made. Where are you referring to 1977? So I think there was a little bit of confusion on that.
In the packet, there are two copies of the estoppel. I hope I'm not mistaken. I may open it. The page.
Maybe I'm only looking at the wrong copy then. I'm only looking at the page 34.
On the page 34, it says April 1st, 1975.
Uh-huh. And on page 66.
Let me find it. I have the flags. Okay, and then page 62 of the
62?
packet, it says, yeah, on page 62, we have April 1st, 77.
Oh, well, yeah, this is a different.
So which
And
one is provided by the tenant, which one by the landlord? Yeah, Mr. Natalizio, maybe.
The one on page 34 was included with, which is the 1975 one, is the one that was included with tenant's application for the MAR determination. And then, at least according to the file, the 1977 one was a part of the landlord's evidence to the hearing examiner. And that's staff's understanding.
And what about page 66?
Page 66. Sorry, give me 1 second.
There's also page
Page
59.
66, that's the hearing examiner's exhibits. So that's the examiner including the tenant submission of the tenant estoppel certificate.
So we've got page 62 that was submitted by the landlord. Is that correct?
That's my understanding, yes.
And page 66 that was submitted by the tenant.
Correct, as a part of the application for the MAR hearing.
So we've got a document that is identical in every way except for that date in the original record.
That's correct.
Did we? I didn't see. I guess was that part of the analysis? I didn't recognize that. I guess
It's a part of. It's a footnote. Staff notes that there is a discrepancy between two tenant estoppel certificates in the record. It was staff's opinion that although there's two different dates, and because neither of the tenant estoppel certificates was signed by either party, it's uncertain which one ultimately was, I guess, submitted or considered by both parties. But it was staff's opinion that ultimately, when you look at the evidence in totality, that discrepancy between 75 and 77 wasn't significant because we have that rent check from 1975. We have testimony from the tenant that he.
Yeah, no, I understand. I agree.
And then also there's the employment agreement, which is signed and dated 79. So regardless if it's 75 or 77, it predates 79, which is when the employment agreement was executed.
Can I say something?
No, sorry, this is our deliberation time right now.
And I'm sorry, Mr. Commissioner Corpus, if I may, would that matter which one was submitted first for the purposes of the determination, whether it was the first submitted by the tenant and the second submitted by the landlord? Would that make any difference? Well, although we know the employment agreement says 1979, but the consideration of this estoppel, I wish it was just completely disregarded by the examiner, but I'm not the examiner. I'm not going to, discuss that. But I just wonder if would that make any difference if, let's say, the 77 was submitted first and the 75 submitted next, or vice versa, or it wouldn't matter.
Are you asking me?
Oh, I'm asking.
Yeah, that's what I thought. Okay.
Sorry, who was that question to, Commissioner Topshin?
My question was that I just as out of curiosity, maybe for clarification purposes, was this 1975 estoppel submitted first and 1977 second? I wonder why the examiner used 1975 for his or her findings, conclusion. If these are pretty much identical, the only thing is different is the date. And I understand the employment agreement, it's dated 1979, but still in the mind of the examiner, if we know why, maybe it's because 75 was submitted first and the examiner received and filed. What was the case here?
But I'll say, at least from staff's review of the file, it's unclear what was submitted first. To the extent that we have the hearing examiner's decision, there's no discussion in it about this discrepancy. To the extent that I can understand the hearing examiner's decision, he based it 1975 on the fact that the tenant testified as to that and produced that rent check and produced this tenant estoppel certificate from 75. And for the hearing examiner, that was sufficient to determine that 75 was when the residential tenancy began.
And the last
beyond that, I was not able to understand it from the record or see in the record.
Right, makes sense. And the last clarification, let's assume even if it's 1977 is the authentic one, all right, or the valid one, it's still predated because the employment agreement says 1979, right? Correct?
That's staff's understanding. Yes.
Okay. Thank you, Mr. President.
All right, Commissioner Griffiths, were you finished? We had other.
Yeah, I can I start, you mean? When can I start? Let's see, I think.
Yes. Yes.
Yes, so I would say that I agree that we should affirm the hearing examiner's decision that the tenancy commenced prior to his employment. There was evidence presented. There was actually eyewitness testimony under oath presented, which does carry weight. There was nothing presented that leads me to believe, or in addition to the check that was for October 1975. So clearly tenancy had started in 75. As was mentioned, the 79 is when he signed the contract. There's no contract presented prior to that. There's no reference in the contract that this is a renewal contract, anything like that, and no evidence presented of that argument. So there's no doubt in my mind that his tenancy began before his employment. The only outstanding question I have and is just to better understand the way the amount is calculated about the banking. It seems to me that there's a reason why the code would allow for the banking of only those certain years. I don't quite understand why exactly, but so I'm open to whatever the rest of the commission agrees to on that amount. I just hope that, if we happen to have another case like this, we'll apply the same standard in the future on how we calculate the rent. And that's all I have to say.
All right, Commissioner Montemayor and then Vice Chair Copeland.
I agree with my colleague on affirming the hearing examiner's decision on the commencement of the tenancy. There's no doubt in my mind, both with the testimony that's in the record, with the check that was supplied. I understand there's frustration without a lease being made available. I think ultimately that's irrelevant given what we have with the check. And ultimately the employment as property manager is also clear based off of the documentation that was supplied as well. So we can all agree that the base rent can start at $275. However, I am confused as well, as Commissioner Curpy stated, around the banked amounts. I feel I need more clarification, be able to make a decision on that. And I would agree, I would like to be consistent with that standard in other decisions that are made. So if the staff attorney could once again explain, I'm so sorry, and I think we probably all have similar questions around this if we've heard it twice already, why the hearing examiner was wrong to apply that standard in this case.
Okay, so the banked amount, I think part of the problem is that the staff's position is that just the banked amount does not apply in this situation, because the banked amount is applying in a situation where the landlord is charging rent to a tenant and ultimately did not impose rent adjustments that they properly noticed onto the tenant. That's the situation in which a banked amount would apply. I understand that there's confusion because of the 1985 to 1996. The best of my understanding is that this is when the Costa-Hawkins law was implemented. And so this was a way to avoid tiptoeing into the issue of vacancy decontrol and being challenged on that front. Beyond that, I don't have, I guess, the institutional knowledge as to what, beyond that, why it was chosen. That's my understanding. But I just, to staff's opinion is that the banked amount doesn't apply. And so we have to look at the base rent definition that does apply.
Does staff have any precedent from any other appeals on the banked amounts?
Well, in terms of banked amounts for situations involving a landlord and a tenant where rent's involved, it's possible. I didn't ask staff to check that. In the situation we have here involving a resident manager, I don't believe staff was able to find any prior decision or hearing that this specific issue has been addressed. I hope you, I guess, can appreciate the nuance of this reading of the municipal code. But if you look at the actual section that governs the base rent, it's clear from that language that all annual general adjustments should be applied to the rent, to the base rent. And that just looking at the definition of banked amount, this is not intending to apply to a situation where there's a resident manager and the resident manager is being terminated and now is returning to a normal tenancy. And part of that is just because of the fact that in this situation, particularly, the tenant, when he was the resident manager, was paying no rent. And so there's just inherently there can be no banked amount because there is no rent that he's paying. And ultimately, there's no annual general adjustments that need to be issued or given him, or he needs to receive notice for, because the landlord is not going to increase the rent on their resident manager because it's built into the employment agreement that it's foregone in lieu of services. And so it's staff's opinion that this section it's just not applicable here. And to the extent, I guess, that the commission wants to know more about banked amounts, I guess it's just staff's opinion that it's just not relevant. And so what we should look at is specifically subsection G of 17.080102, which is how we determine the base rent in this specific scenario. And if you just give me just a little bit more, I'll try to be as brief as possible. Forgive me if eyes are glazing over. And so if we look at that subsection G, without looking at the exception that applies here, because there is a agreement that sets forth the value of rent for what the services being provided are, if you were looking at subsection G without that exception, what it says is that when a tenant is a tenant and then later becomes the resident manager and then is terminated, the way the base rent is determined is that it's the rent, the base rent shall be the same as the base rent charged for a unit in the building with the same number of bedrooms, adjusted by any annual adjustments permitted under the RSO. So in a situation where there's a property or a resident manager in a single bedroom, and in the building there's only one other single bedroom unit, according to this, in that scenario, after the resident manager was terminated, the base rent would now go to whatever that other single bedroom unit's base rent is, plus all the AGAs. And when the situation where there's multiple units in the property that share the same amount of bedrooms, so let's say there's 4 single bedrooms, then it's the average, but it's always including all of the permissible annual general adjustments permitted under the RSO. So even though there's an exception here where it says unless the amount of the rent can be established from the parties' agreement concerning the resident manager's services, it's staff's understanding that based upon this section, you don't just stop at 1996. It would be all annual general adjustments that must be applied, because that's how the rest of the section reads.
Understood.
Okay.
Thank you. With that, I would feel comfortable moving forward with staff's recommendation to reverse the hearing examiner's decision on this item.
All right, thank you for that. I believe Vice Chair Copeland was up.
Yeah, with regard to the estoppel form question, I was looking at the forms and they're dated 2013. And the question 1E is current rent. It doesn't say initial rent. It says current and none, which was accurate in 2013. There was no rent paid because it was in lieu of management duties. So I think that's, I don't really have a problem with that. It also lists the security deposit as $175, which is common to have a 1 month's, rent. And he has a canceled check for $175 from 1975, the employment contract from 1979. So I think there's sufficient evidence that the tenancy commenced before the employment as a resident manager. And I'm satisfied with the calculations and the explanation that the staff attorney gave us as far as banking versus all cumulative annual increases. So I would be supportive of staff's recommendation on this.
Thank you, Vice Chair Copeland. So I have a few comments. I agree, and it's important to note that I appreciate, one, that the parties were respectful, but I do have to say that the landlord's comments were mostly speculation without any evidence to back up those comments. So I don't think that there was a lot there. When we have evidence in the record and testimony at the hearing that the tenancy started in 75, the employment started in 79. We have a contract stating as such. Vice Chair Copeland made a very good point that on the estoppel, a security deposit of 175 would match a 1 month rent amount, as opposed to it all being zeroed out. I have to say I've worked with 1.5 billion tenant estoppel certificates, and it's not uncommon that they are a little bit sloppy or confusing. Generally, what happens is a landlord or a person buying a property says, hey, here's this form, you need to fill it out, or an attorney does. Landlord doesn't get a lot of direction or understanding of what it is, so they fill it out to their best of ability. And so having it be a little bit confusing isn't too surprising to me. And I do think that final explanation from staff council tonight going through the MAR and the definitions under subsection G, that to calculate the base rent and that we aren't doing the banked exception is correct. It is a confusing topic, but I think spending as much and ample time as we have here, we've kind of worked through a lot of the minutia and the confusing aspects of that. So like some of my fellow commissioners, I feel comfortable and I do agree with the staff's recommendations. So I know we have a few varying opinions here. Does anyone want to make further comments? Yes, Commissioner Topship.
Yes, thank you, Chair. Since I had those doubts at the beginning, and that's I wanted to come back and explain for the record that based on the further discussion and by this commission, and also thank you, Mr. Natalizio, for the clarification. So I do believe that we have sufficient documents to support the predated tenancy, and that check, that cancel check, that rent check, it's the I would say that's the most important document here. Even if we question the 2013 estoppel of both versions, 75 tenants versus 77, even if we disregard that, it's based on the employment agreement, which is from 1979, and the check that we have, it's definitely is predated the tenancy. So I'm fully confident to support that part of the recommendation. And in regards to the bank amount, again, thank you, legal counsel. And yeah, I do believe that the exemption from in the ordinance, the way it's described, that applies to the resident manager situation here. And because we have the employment agreement that sets the MAR for the unit, so therefore the bank amounts would not be applicable. So I'm fully confident, and I'm ready to support fully the findings and the recommendation in this case. Thank you.
Thank you. Yes, Commissioner Ayers.
I just want to add that I'm also in agreement with the majority of our commissioners here that the way the city staff has approached the calculation of the MAR seems right and reasonable and fair. So I just want to put that out there.
Great, thank you. Any additional comments, or I would entertain a motion?
Entertain a motion.
And the motion would be?
My motion would be to adopt resolution RSC 21-599, a resolution of the Rent Stabilization Commission of the City of West Hollywood, affirming in part, reversing in part, and modifying in part the hearing examiner's decision as to application number D-4582.
Thank you. Do we have a second?
I'll second.
All right, we have a motion and a second. May we have a roll call, please?
Commissioner Ayers,
Aye.
Commissioner Perpes,
Aye.
Commissioner Montemayor,
Aye.
Commissioner Topchin,
Aye.
Vice Chair Copeland,
Aye.
Chair Marks.
Aye. The motion passes. The parties are going to be placed back into the waiting room. If you wish to discuss further, you can reach out to the Rent Stabilization Division at rsh@weho.org or 323-848-6450. Thank you to everyone who participated tonight. Thank you. All right, moving on to new and unfinished business. I know we have unfinished business from last week. We had a resolution to discuss. Mr. Hollow or Mr. Natalie. Sorry, would you pronounce your name for me so I can say it correctly every time?
Sure, it's Natalizio.
Yeah, it's Alicia. Thank you. I apologize.
May I ask a quick
yes.
process question? As I wasn't here for the last commission meeting, should I recuse myself for this item?
Although you weren't here, the way you could participate would be if you state that you've reviewed the prior meeting and watch it in its entirety. But if you didn't,
I did not.
Okay, and yeah, but best course.
I can tell you right now, I did not.
Best course then would be to recuse or abstain from participating.
All right, I will recuse myself and remove myself from the meeting.
Great. Thank you.
So, okay, Chair, I'll take this. I apologize. Everyone has to listen to me talk again. I'm sure everyone's falling asleep listening to my monotone voice. But so this is resolution 21-598 for a refresher. Last meeting, this was the case involving a unit on Havenhurst, and it was involving a heater that was originally a furnace that was replaced, and it was originally heating the living room, dining room, kitchen area that broke. It was replaced with a wall heater, and there was a dispute about whether or not that wall heater was sufficient to meet the compliance request. And the commission, I guess, original staff's recommendation was to make various remands. Staff found that based upon the evidence in the record, that there was substantial evidence to support the hearing examiner's decision. And so the motion was to order staff to return with a resolution, making the findings discussed during commission's deliberation. And so this is the updated resolution to reflect that deliberation and findings. And really the primary change is going to be in section 4 that discusses the findings. And so here you'll see that the commission is going to affirm the hearing examiner's decision that essentially states that the landlord did not comply with the original D-4503 decision to make sure that there was adequate heating in the unit. And then there are the listed facts and evidence supporting that that affirmation by the commission. If you want me to go through those, I can, or if there's questions, I can just wait for that, or if there's nothing else, I can stop talking.
Commissioner has any questions? We have Commissioner Maggio present with us. He will join us for the final exciting moments of the evening. He won't get to listen to much more staff counsel speak. So.
Sure, may I have a moment to apologize?
Sure, go ahead.
Well, everything went off. Not me, but my computer and the internet. So, but guess what? I'm a Trojan. I still try to be here.
You did. You get extra credit for being here for this portion of it. So
and I have read my packet, and I do understand what's going on. Thank you very much.
As we always know you do. So we are on the unfinished business portion of this. We just got a summary of where we're at. Commissioners, any questions about that presentation there? Seeing none, I would entertain a motion on this.
Motion to approve resolution of the rent stabilization. Resolution RSC number 21-598, a resolution of the Rent Stabilization Commission of the City of West Hollywood affirming the hearing examiner's decision as to the application number D-4503CD2.
Perfect.
I'll second.
We have a motion. We have a second. May we have a roll call, please? Sorry. Yes, Commissioner Maggio, go ahead. Yes.
For legal counsel, because I've been off camera all this time, would it be appropriate for me to vote?
Yes, this isn't a public hearing. You were present at the last meeting. I guess if you have any questions as to what specifically was made in the updated resolution, I can update that for you, but you can fully participate in this vote.
To legal counsel, I do understand the new resolution because I've read it, and as long as I have your clearance, then I feel comfortable. Thank you, sir.
Great. We will go to a roll call, please.
Commissioner Ayers,
Aye.
Commissioner Kirkes,
Aye.
Commissioner Maggio,
Aye.
Commissioner Montemayor. Oh, sorry, excuse himself. Commissioner Topchin,
Aye.
Vice Chair Copeland,
Aye.
Chair Marks.
Aye. The motion passes. Thank you for the roll call.
One thing, did I read the right one into the record though? Did I'm looking at my pages now. Did I read the right?
Yes, you did,
Yes.
Commissioner.
I did? Okay, good. Thank you.
Yeah, I always get confused with those two. All right, so we are moving on to items from staff. Do we have any staff comments or presentations here?
No comments from staff. Thank you.
All right, thank you. Moving on to public comment. Do we have any public comment come on?
Not at this time.
Okay, great. Moving on to items from commissioners. Yes, Mr. Maggio.
To the manager, I was asked by many if we are going to have that program that LA has where they register affordable units.
There's no pending item on that. If you'd like to discuss that with me offline, we can talk about it, but not at the moment.
Would it be something that would be appropriate if we agendize that topic for an upcoming meeting?
We can certainly talk about it. I'd like to get more information about what it, I'm not actually, I understand the concept based on your description, but I'm not completely familiar with it. So if you want to talk about it some more, we can look into it and see if it's an appropriate item to agendize.
All right, then I will call you and have a discussion. I think that would be appropriate. And then if it's fruitful, maybe we could bring it before the commission.
Very good.
Thank you, sir.
Thank you. Yes, Commissioner Kirby.
I was just going to ask it if maybe if staff could take a look at the discussion we had tonight about that the banking and find out if that's still a relevant section of the code, and if it's determined not, maybe we could remove that so to make it less confusing. But I don't, let staff figure out whether it is still relevant or not under certain other hypothetical cases that could come in front of us. Because I just don't understand that why we still have it in there if the way it's worded about the banking of this the window of time to 1996 or something.
I think that one we might want to take up, offline as well, just so I'm clear about what you're asking. Because I have a short answer if I understand the question, but I don't want to give it unless I'm completely clear on what it is you're asking. So we can discuss that as well.
Yeah, I guess my question would be: could staff take? I mean, if you know the answer that it is still relevant, just tell us, and I'll drop it. It's no big deal. But
you're talking about the section that talks about banking, the AGAs from 85 through 96, just that section of the code.
Yeah, to find out if it still has relevance in today's.
Yeah, it could.
Okay, then leave it. Great,
Okay.
thanks.
Right. Thanks.
No work for you.
Yes, Mr. Maggio.
I'm sorry, to the manager. I wasn't sure if I made clear what my request was, and it was to look into requirement of public listing of new affordable housing so people know that what is on a list.
You mean a list of inclusion, like for example, a list of inclusionary units?
Well, I know Los Angeles has just asked to require public listings of new affordable housing units.
Okay.
And why am I hearing this? And I want to know, because I want to be ahead of the game. If this is happening, this could be something we should look into and discuss.
Okay. Just let's talk about it some more. I'd like to find out more about it.
All right, thank you.
Mm-hmm.
Great. Any other commissioner comments? I see none. All right. The meeting is adjourned to the next regularly scheduled meeting of the Rent Stabilization Commission to be held on September 23rd, 2021 via teleconference. Thank you, everyone.
Thank you. Good night.
Good night, everyone.
Good night,
Good
everyone.
night.
Thank
Good
you.
night. Appreciate it. Bye-bye.